So you've been accused of domestic violence, and now the judge is talking about something called Family Code Section 3044. Suddenly, your custody rights feel like they're slipping away, even if the allegations aren't true. What is Family Code Section 3044, and how does it impact your ability to see your kids? And most importantly, how do you fight back? I'm Mark Reel Jr., the Fathers Rights Attorney, and if you're a father in Southern California dealing with domestic violence accusations, you must understand how Family Code Section 3044 works, because the statute can create a legal presumption that you shouldn't have joint or full custody of your children. In this video, I'll explain what Family Code Section 3044 actually says, how long it affects your case, how you can rebut the presumption and protect your rights as a dad. If you're facing DV allegations in family court, don't wait. Click the link in the description to schedule a free case evaluation with my team at Real Fathers Rights, because we fight these cases every single day. Starting out here, what is Family Code Section 3044? Let's break down what the code says and what it really means. Family Code Section 3044 creates a rebuttable presumption that it is not in the best interest of the child for a parent who has committed domestic violence to have sole or joint physical custody of a child. In plain English, if the court finds that you have committed domestic violence even once, you start your custody case with the court presumed against you. And the DV doesn't have to be a conviction. It can be a finding in a restraining order, a past incident the judge finds credible, or even a claim made during the family law hearing if the court believes it. Here's the key. The presumption doesn't mean you lose automatically, but it flips the burden. You now have to prove that giving you custody is safe, healthy, and in the child's best interests. What counts as domestic violence? Most people think DV means hitting or physical abuse, but under California law, unfortunately, it includes much more. Domestic violence can include threats, intimidation, or coercion, harassing texts or calls, controlling behavior, emotional abuse, and property destruction. Even verbal altercations, if they cause reasonable fear, can be considered domestic violence. That means a heated argument, a door slammed, or an ugly breakup could easily be used to justify a finding of domestic violence, creating a 3044 presumption. This is why you must take every DV accusation seriously, no matter how exaggerated or false it seems. How long does the 3044 presumption last? Once the court finds that Family Code 3044 applies, the presumption stays in effect for 5 years unless you successfully rebut it. Even if your restraining order expires in 1 or 3 years, the custody penalty lasts for 5. This can impact legal custody, which is decision making, physical custody, your actual time with the children, your ability to modify existing orders, and your ability to attain 50-50 custody in the future, as the presumption case law states you shouldn't have more than 30% custody. That's why your goal isn't just wait it out. Your goal is to rebut it immediately. How to rebut the 3044 presumption. Here's the good news. Family Code Section 3044 is rebuttable. That means that if you present enough credible evidence, the judge can decide the presumption no longer applies. Now, this can be challenging given the strong case law around it, but to rebut the presumption, the court is required to consider 7 specific factors. Number 1, whether you've completed the 52-week batterers program. Number 2, whether you've completed drug and alcohol treatment if it was ordered. Number 3, whether you've complied with court orders. Number 4, whether you've committed further abuse. Number 5, whether it's in the child's best interest. Number 6, whether the other parent is also abusive. And number 7, whether the parent seeking custody is acting in good faith. It's no longer enough to just say, I'm a good dad. You need documented steps and a clear legal plan to walk the judge through each of these points. This is exactly what we do at Real Fathers Rights every day. Build strategic rebuttal that the court can't ignore. Real talk. What do the judges actually look for? Judges don't want to take kids away from safe, involved fathers. But when Family Code Section 3044 is triggered, the judge gets cautious. They're under pressure to protect the child above all else. And this includes situations where you feel like the allegation was exaggerated or even manipulated. This means how you show up in court matters. How you act during exchanges matters. What you post online matters. What your texts say matters. You need to show the the judge that you are safe, you are stable, and you are child-focused. And you've taken real steps to grow from whatever was alleged, even if it wasn't true. This is a courtroom, not a character contest, not a therapy session. You need a legal defense, not just a heartfelt apology. My final thoughts. The bottom line is, I don't like Family Code Section 3044. I believe it creates perverse incentives to accuse someone of domestic violence. But still, it is a powerful law that can take custody away from fathers, even without a conviction. If it's used against you, your entire case changes overnight. But with the right legal strategy, evidence, and presentation, you can rebut the presumption and fight for the parenting plan your kids deserve. If you've been accused of domestic violence in Southern California Family Court, don't wait. Click the link or call the number in the description to schedule a no-obligation case evaluation with my team here at Real Fathers Rights. Let's build a plan that protects your future. Thanks for watching The Fathers Rights Attorney. Like and subscribe to our channel and drop a comment if you have faced a 3044 presumption or you have a question about your family law case. And we'll see you guys next time.